Tonight on This Law, we're finding out new details about the accused killer in an Orlando mass shooting that killed 50 people. The wife of Omar Mateen says she knew he was planning on attacking people at the nightclub and tried to stop him. Let's bring on our legal analyst, Attorney Jay Davis, to talk more about this. Jay, you followed up on the story. Can she face any criminal charges for saying that she knew about this and didn't alert the police?
That's what a lot of people are wondering, is just the fact that you know something before it happened, does that create some duty, some sort of obligation that you have to tell? And the general rule is not. There is some misprision of a felony, which is if you know a felony actually occurred, that creates some criminal liability. So some prosecutors can work with that and create it on her. But the thing that's more important here, that seems to be a lot of talk, but there's actual things that she did in this particular case that could make her an accessory or possibly a co-conspirator in the case, and that's driving. We don't know exactly how these things occurred, but there's apparently factual basis for believing that she drove him to get the gun. Did she just drive him to get a gun, not knowing anything about why he was going to use that? That doesn't create any criminal intent. The same thing with the nightclub. They could have gone to this nightclub. We don't know. I don't know. The facts don't show whether or not they went in, whether or not, when they say he went there to case it, did they go in together and think, she might have thought they were just going into the nightclub, whereas he was going in to case it. So we don't know what she knew when. So it's important to know, did she know at the time he went to the nightclub that it was to case it? And if that is the case, then she was a part of it, and she was a part of that developing crime. So she should have gotten herself out of it by going to the police. But if she just knew about it, if all these things happened, and then later he says, you know what I'm going to do? I'm going to use that gun I just bought, and I'm going to go to that nightclub we went to, and I'm going to kill a bunch of people. If that's the first point that she knew about it, then the criminal liability is probably not there for her.
Now, legally speaking, is there something that stands in the way of that? If you feel pressure to alert law enforcement or alert authorities, if you know somebody that you're close to, a loved one, a spouse, something like that, is there something that stands in the way of that, or you can say you hide behind that because you don't?
You're not going to have. There's things called spousal immunity, and that is if your spouse somehow confesses something to you, that might not be disclosable to someone else. You might have a right to hold that in confidence as a state measure to make sure spousal relationships are good and pure, so that if you say something, you don't have to worry about your spouse telling on you or that type of thing. But when you become a co-conspirator in it, when you know about something that's going to happen in the future, and that's been told to you, and you're somehow involved in it, you have to get yourself out of it. So if once she knew she drove him, once she knew she was a part of that developing crime, she needed to back herself out of it in order to avoid being part of the conspiracy, that's this up.
Even if she says she tried to stop it, she tried to stop him from doing it?
Trying to stop him from doing it once, if she was involved in it, and I'm not saying yet that she was involved in it, but if she was, trying to stop him is not enough. She has to make stronger effort to try to stop it from happening in the best way that she could, which the very least of which would be called law enforcement.